Hey everybody, welcome back to the Shanty. So, you guys know me. I'm an old man. As a matter of fact, I'm getting to be that old man that yells at kids on my grass. Get off my lawn, that old man. I am certainly the old man at the law firm when we get summer associates in like we have now and young associates in and I see somebody walking down the hall I don't know and I'm like, oh, who the heck is that? And, why are we hiring 12-year-olds? Because I'm that old man. I'm kidding, we don't hire 12-year-olds. They just look so young. Maybe it's just me getting so old. So, what's that got to do with anything? Well, sometimes I realize I'm old when I read some of the stuff that's going on in the news. And what's going on in the news today? What's the big topic? What's everybody talking about? Well, one of the things that everybody's talking about is so-called artificial intelligence, which I find really funny because it is certainly artificial, but I'm not sure how intelligent it is. And again, that's a reflection of my age. I think before we deal with artificial intelligence, we ought to start dealing with natural stupidity. But that's, again, just my opinion. What's artificial intelligence got to do with an employment law blog? Well, what it's got to do with an employment law blog is that the EEOC is also obviously concerned about artificial intelligence, so concerned that they just issued 2 sets of guidance on artificial intelligence. The first is called Select Issues Assessing Adverse Impact in Software, Algorithms, and Artificial Intelligence Used in Employment Selection Procedures under Title VII of the Civil Rights Act of 1964. And that's one set of guidance that they issued. And the second one is called the Americans with Disabilities Act and the Use of Software, Algorithms, and Artificial Intelligence to Assess Job Applicants and Employees. So what are we talking about when we talk about artificial intelligence in this context? Well, the EEOC in both sets of guidance gives us a definition of what they're talking about when they talk about artificial intelligence. And I'm going to read some in this one, okay? So here's what the EEOC's definition of artificial intelligence is. And they take this from the National Artificial Intelligence Initiative Act of 2020 at section 5002, open paren 3, close paren. Artificial intelligence. Some employers and software vendors use AI when developing algorithms to help employers evaluate, rate, and make other decisions about job applicants and employees. While the public usage of this term is evolving, Congress defined AI to mean a, quote, machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments, end quote. In the employment context, using AI is typically meant that the developer relies partly on the computer's own analysis of data to determine which criteria to use when making decisions. AI may include machine learning, computer vision, natural language processing and understanding, intelligent decision support systems, and autonomous decisions. That's the EEOC's definition of AI. So why is this an issue? And we'll start with Title VII, under Title VII. Why is it an issue under Title VII? Well, this is 2 ways you can discriminate under Title VII, as you all know. One is adverse action, intentional discrimination. I took an intentional decision to discriminate you because of your membership in a protected category. And the other is adverse impact or disparate impact. It's called both, which means you have a facially neutral policy that has an adverse impact on a certain group that is protected under Title VII, like sex or age or race or national origin. What we're talking about in this guidance is that it is disparate impact. And disparate impact is, there's actually uniform selection guidance that the EEOC issued way back in 1978, before anybody had heard of artificial intelligence, that deals with tests and selection criteria and the issue of disparate impact. So what the EEOC has done is they've taken this artificial intelligence thing and rolled it into that guidance to see how this works. So what disparate impact analysis works like this. First, you have to say, do we use a particular employment practice that has a disparate impact on a protected group? That is, does it select out members of a specific group? In other words, if I use a test, say a physical agility test, and women score more poorly on that physical agility test than men do, that screens out a protected group. It screens out women. If the selection procedure has a disparate impact, the next question you have to ask under the analysis is it job-related and justified by business necessity? That is it measuring things that actually predict success in the job? Real things you have to do in the job. And that's critical here, because if it's not, you can't use it. If you show that the thing is job-related and justified by business necessity, that's still not the end, because the EEOC wants to know, is there a less discriminatory alternative to measure the same things? And if there is, you have to use that. And if there isn't, then you could potentially use the selection criteria. And again, all of that goes back to, way back to 1978. So in this new set of guidance, the EEOC asks a bunch of questions and answers, and we're going to talk about a couple of those questions and answers. And here's the first one that you need to know about. I'm obviously not developing my own artificial intelligence tool to select applicants. So they have to answer a bunch of questions, and then the tool screens the people out and tells me which candidates are good candidates and which candidates are bad candidates. At least I think that's how it works. I didn't write that. A vendor wrote it. So the first question the EEOC answers, not the first question, but the first one we're going to talk about is an employer responsible under Title VII for its use of algorithmic decision-making tools, even if the tools are designed and or administered by another entity, such as a software vendor? And not surprisingly, the answer to that is yes. You are responsible. Even if you didn't develop the tools, you are responsible. All right? Now, the EEOC says it this way. In many cases, yes. For example, if an employer administers a selection procedure, it may be responsible under Title VII if the procedure discriminates on a basis prohibited by Title VII, even if the test was developed by an outside vendor. In addition, employers may be held responsible for the actions of their agents, which may include entities such as software vendors, if the employer has given them authority to act on the employer's behalf. This may include situations where an employer relies on the results of a selection procedure that an agent administers on its behalf. So, lesson number one out of all of this is you can't just say, I bought it from somebody else. They told me it wasn't discriminatory, so it's good. Question number two, how do we know if the tool has a disparate impact? Well, the EEOC there's this thing called the 4/5 rule. And again, this goes way back to the 78 guidance, the 4/5 rule. And the 4/5 rule is a rule of thumb referenced in those earlier guidelines. That's a general rule of thumb determining when the selection rate is substantially different for one group than for another group. In other words, is the selection rate substantially different for women than it is for men? And you do this mathematical calculation, and it involves 4/5, and that gives you an idea. If you pass the 4/5 rule, you're probably okay. If you fail the 4/5 rule, you're probably not. I'm not going to go into this in detail, but if you want to know about it and learn about it, you know what to do, to call us. Now, the EEOC does say this. The EEOC encourages employers to conduct self-analysis on an ongoing basis to determine whether their employment practices have a disproportionately large negative effect on a basis prohibited under Title VII or treat protected groups differently. Generally, employers can proactively change practices going forward if they determine that there's a problem using the 4/5 rule. So what do you do? How do you protect yourself in this particular situation under Title VII? Well, the first thing you need to do is understand what you're doing with these selection tools. What role do they play in you making a selection of a candidate? Are you relying on them 100% to initially screen out candidates? Or is it just one more data point? The second thing you have to do is what the EEOC just wants you to do here. You've got to look at this thing and determine whether or not it's violating the 4/5 rule. And my recommendation is you do that before you start using it, not after you start using it. Well, how do you do that? Well, we'd have to talk about that. But one of the ways you could do it is you've got a bunch of people in a job right now. Give them the test and see if you know which ones are good and which ones are bad. Give them the test and see if the good ones do well and the bad ones do poorly. Because if it's vice versa, you've got a problem. And I want you to do that with us, because we want to protect it by the privilege, right? We want to try to make that analysis privileged. Don't just go out and do it on your own. And if you do find a disparate impact, then you either have to change the tool or fix the tool or get a new tool. Okay? So you want to do that up front before you get the lawsuit, not afterwards. All right, what about this other guidance on the ADA? What has this got to do with the Americans with Disabilities Act? Well, under this particular set of guidance, the EEOC asks, how could employers' use of algorithmic decision-making tools violate the ADA? What a great question. I'm glad we asked it, or the EEOC asked it. So the EEOC says there's really three common ways that these things can violate the ADA. One is the employer does not provide a reasonable accommodation that is necessary for a job application or employee to be rated fairly and accurately by in this guidance, they use the word algorithm, not the AI, by the algorithm. All right? In other words, don't forget, if we're using a selection tool, any selection tool, physical agility test or artificial intelligence, to measure candidates and see whether or not they can do the job, a candidate is entitled to a reasonable accommodation to allow them to be able to use the tool. Okay? You don't just reasonably accommodate your employees, you also have to reasonably accommodate job applications if they're disabled. The second way the EEOC says that these things could violate the ADA is if they screen out an individual with a disability, even though the individual with a disability is able to do the job with a reasonable accommodation. Now, the EEOC says screen out, quote unquote, occurs when a disability prevents a job applicant or employee from meeting or lowers their performance on a selection criteria, and the applicant or employee loses a job opportunity as a result. A disability could have this effect by, for example, reducing the accuracy of the assessment, creating special circumstances that have not been taken into account, or preventing the individual from participating in the assessment altogether. And the third way that the assessment tools could violate the ADA is if they ask disability-related inquiries or require a medical examination at the improper point in the process. So this selection criteria, this guidance also gives you some things you can do. As a matter of fact, the question says, what could an employer do to reduce the chances that algorithmic decision-making tools will screen out someone because of a disability, even though that individual is able to perform the essential functions of a job with a reasonable accommodation if one is legally required? They say, first, if an employer is deciding whether to rely on an algorithmic decision-making tool developed by a software vendor, you should ask, they say you might want to. No, you should ask the vendor whether the tool has been developed with individuals with disabilities in mind, okay? If you're developing your own algorithmic decision-making tool, you could reduce the chances of, as the EEOC says, unintentionally screening out by taking the same considerations into account in the development of your process. Now, I don't know enough about how these things are developed to tell you how to do that, but you've got experts that do. The EEOC says, depending on the type of tool in question, reliance on experts on various types of disability throughout the development process may be effective. All right? Second, according to the EEOC, regardless of whether you develop the tool or whether somebody else develops the tool, you can take additional steps to make sure you're okay by, number one, clearly indicating that reasonable accommodations, including alternate forms and alternate tests, are available to people with disabilities. Two, providing clear instructions for requesting an accommodation. And three, in advance of the assessment, providing all job applicants and employees who are undergoing the assessment by the decision-making tool with as much information as possible, including information about which traits or characteristics the tool is designed to measure, the methods by which they're measured, and the disabilities, if any, that might potentially lower the assessment result or cause a screen out. So that's what the EEOC is saying you can do in this situation. All right, so what does all this mean for you? Does it mean you don't use AI in your selection process? Doesn't mean that at all. What it does mean is before you use AI in the assessment process, you better read these guidances and you better talk to us about whether or not you're going to have a problem. And we are going to want to, as you're using these tools, continually analyze the tools to make sure that they're not creating a disparate impact that's going to get you in trouble down the line. This is how, again, this is how the Terminator started. I'm an old man, it scares me to death. But hope that was helpful. This is a longer one than normal. And I have an announcement. Just so all you know, the Shanty's going to take a few-week break because I'm leaving the country. So I'll see you when I get back. Enjoy your summer, and I'll talk to you all soon.